How's jail? Sucks.
It's not for me.
It's not supposed to. That's what I want to hear. You know? Do you speak Spanish?
Sir.
My mom used to tell me, Dime con quién andas, yo te digo quién eres. Tell me who you hang out with, and I'll tell you who you are. That's what life is. When you hang out with dogs, you're going to end up with fleas. I don't know if that's what's happening now, but I told you I don't want you smoking, and it's continuing to happen. Now, what should we do? Should we let him out? What do you think, Mom?
I agree with the same curfew. I want the same curfew. He has everything, just maybe drug test randomly.
What do you think?
Yeah, I'd like to see him out. Number one, Judge. I mean, his mom, he's got asthma. I think he's learned he needs to be out of there. I think he understands using the friends as an excuse is not going to fly. Being around people that smoke weed, that ain't going to get you positive. I explained that to him. Based on the videos, which I watched, he needs to understand who you're hanging out with is the reason you're getting in trouble. Like Judge said. Okay?
You know, you have but one life. The more cases you start catching, the harder life gets. It doesn't get easier. The older you get bigger, fatter, uglier, you lose hair. Life doesn't get easier. And if you don't have a trade, if you don't have an education, you're going to end up in and out like all those other mofos in there now. Look at all the old timers in there. They're children who never grew up, never did anything with themselves, never amounted to anything. So all they do, they end up doing dope, they end up stealing that's not a life, man. You got a mom that cares.
You understand you're here because you got in a car of someone else driving that decided not to stop, right? You understand who you're hanging out with is getting you in trouble. They've now landed you in jail 2 times. You understand that, right?
Yes, sir.
The day you got arrested and now when Judge put you back in. And you can blame your friends for the second time Judge revoking your bond. But you need to understand you are putting yourself in this position by choosing to be around these people. So it's your decision how this goes. Okay?
Yes, sir.
I'm here to help you and get you out of this. But you got to help yourself. You got it?
Yes, sir.
Okay.
No hanging around with these people. It is a condition of your bond.
Sir.
I will give you another chance, but I will not play this game with you again. You continue to smoke. You continue to hang out with the people that you're hanging out with, or you pick up a new case. I'm going to put you in, and I will not let you out again. You will be stuck like Chuck until this case is over with. And I tell you, it takes 9 months just to get a damn 911 tape. I'm all over the state repeatedly because of it. Do you understand?
Yes, sir.
This is the last chance you have with me. Okay? I'll reinstate the bond today. Same conditions fly. We test him in 40 days again, 40 to 45 days. If you're dirty again, get ready. You understand?
I'm also giving random drug tests too from the agency I work with, so just to keep up with.
Well, he's going to test with us. I want to know because I know.
No, definitely.
Right. Okay. All right, man. Make me proud. That's all I'm asking you to do.
Yes, sir.
So what is he doing now? Is he in school or
Yes.
full time, right?
Yes.
Okay. All right. Keep it up.
And I'm going to get a mitigation packet in here.
Done.
Okay.
All right. You're out today.
So much.
It's the last chance.
Yes, sir.
Okay, man.
Thank you.
You got it.
Reset when you,
What do you want?
okay, normal. Okay.
You are on bond for a theft, and now you've picked up another theft and an evading arrest. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On February 13th, officers were dispatched to a theft call at Lowe's. The officer spoke to the complaining witness, who's the loss prevention officer. The loss prevention officer stated that the defendant entered the store and put a speaker into his backpack. The loss prevention officer followed the defendant around the store. The defendant walked out of the store, passing all points of sale.
Hold on.
To purchase the item.
Oh, you didn't?
Yeah.
I was going to give him a coloring book. Okay, go ahead. So he's in Lowe's?
Yes.
All right.
The complaining witness attempted to stop the defendant. The defendant did not stop. The officer was on scene when the complaining witness was attempting to stop the defendant. The officer told the defendant to stop running, and the defendant did not comply. The defendant ran approximately half a mile from the Lowe's. The officer caught up with the defendant on the 3rd floor of an apartment complex. The defendant attempted to resist detainment. The value of the item stolen was $129. And the defendant started to run from the complaining witness towards the nearby apartment.
Mr. Castillo, I'm going to find that there's probable cause to go forward on your theft and your evading arrest. Deputy Miranda, I'm now revoking your bond on your first case. You will now go into custody. I told you not to pick up any new cases. You've picked up 2 new cases. You will now stay with me. Goes with you.
I'm sorry about that, sir.
Can you appoint him a lawyer, please? I will appoint you a lawyer now and we'll talk, but no, you can't continue. Unacceptable. Are you Jackson Norton?
Sir,
Mr. Norton, you were charged with 2 counts of assault bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
February 15th, officers responding to 1025 West Mass Parkway, bar Buckwild in Harris County, Texas, regarding a disturbance. The first complainant stated that he was located at the bar ordering drinks and was in a conversation with the defendant. After the complainant turned around and the defendant struck him on the right side of his face. A second complainant stated that he observed that the defendant was leaning over the first complainant, physically hitting the first complainant. In an attempt to break it up, the second complainant grabbed the defendant and the defendant turned around and punched him on the side of the head. The second complainant stated that he believed he was unconscious for multiple seconds. When he woke up, he was lying on the ground. The defendant left the establishment where his bouncers were able to locate and detain the defendant in the parking lot. A witness, the bartender, observed his still on the second complainant. The second complainant had injuries to the left side of his face where it was pink, and there appeared to be broken blood vessels under the skin, with a small laceration near the end of his eyebrow, where there was a small amount of blood. The first complainant advised he felt pain and had a small lesion on the end of his elbow next to his eyebrow next to his hair.
So we have 2 assaults that were dismissed early last year. Any of the complaining witnesses the same?
No, Judge.
Same set of facts, whereas alcohol as well?
The previous assaults happened at a high school graduation party.
But there was alcohol?
Yes, Judge, it's not like that was alcohol.
Mr. Norton, I'm now going to find that there's probable cause to go forward with your case. I'm now putting an ankle monitor on you so I know that you're not consuming alcohol. If I find that you do, I will put you in jail and I'm going to make your bond high. Do you understand?
yes, sir.
We're now working on our 4th, so I will do everything in my power to protect my public at all costs. Do not use alcohol, do not use illegal drugs, no weapons, no going to any bars, clubs, establishments where it's 50% or more alcohol, no going out in the middle of the night. You will get a curfew as well.
Judge GPS. Whisper.
Sure.
Nine to 6.
Sure, yeah.
Judge, I leave earlier in the morning for work.
I'll give you a lawyer. I'll have the lawyer talk with you, work out any kind of detail, but my concern and my only concern is the protection of my city, and I'm going to do it at all costs.
Yes, sir.
Do you understand?
Yes, sir.
Nothing else matters to me in this life right now. If I find that you're a danger, I only have one place for you.
Yes, sir.
Waive all the fees, please. Mr. Norton, I'll have you fill out an application for an appointed lawyer and I'll see whether you qualify. I'll have you go to Victoria, sign a reset. Deputy Miranda's going to give you an application. I'll have you take your seat in the jury box. Do not leave until you sign all the conditions. And then I'll take a look at the application, sir.
Yes, sir.
Jackson Norton, you just gave him bond conditions, and I wanted to know if we can amend the curfew because of his work.
Okay, I knew that he had issues. What would you like?
Judge, he'd just like to remove the curfew, but keep the restriction from any bars or alcohol, or places that serve alcohol, so that he doesn't go around there. But his
So
job
what I
is-
said is he cannot go to any establishment where it's 50% or more, where there's like a true bar, if he's going to like a Longhorn Steakhouse, if he's going to, Papacitos, that's okay. But if you're going to a bar like the Marquee or you're going to, that's unacceptable. No bars, nightclubs, anything of this nature, because I don't want him to, I mean, we're working on our fourth assault now. No, and so I don't want him out in the middle of the night. I'm willing to work with you on the curfew, but
So from what he's told me, he works 8-hour shifts, but he's also he's maintenance. So he can be on call and he have to leave at 4 o'clock in the morning to get to work if there's an emergency. So he just wants to make sure that he won't be violating bond conditions if he has to go to work. My documentation that he.
right, I need proof because I'm not going to take his word for it. So bring me proof and then we can talk. But yeah, I mean, I'm not going to take his word for it that he gets up at 3 a.m. or 2 a.m. to go to this place and that place and, So, but show me something like that and then, yeah, we can work.
Okay, so we'll keep the curfew in place and then if he needs to travel forward, we can provide proof that he's clocking in and clocking out.
No contact with any of the complaining witnesses, no weapons. And then he's got the device on his ankle, so we know he's not consuming it too.
Is that a scram? Okay. So scram and GPS is what you're doing?
No, I didn't. Well, yeah, I guess so that we know that he's not out in the middle of the night, and if after some time, if he's good, then we can amend the conditions as far as the GPS.
Okay.
Scram.
30 to 60 days?
I mean, be proactive. You know what I mean? Show me, I want to know that there are not going to be any more issues, but yeah, okay. Thanks,
You said
Debbie.
7 to 7?
No. I don't know. He said he had a problem with 6. I didn't know. What did I do? I didn't do 7 to 7.
We're gonna do 9 to, the standard 9 to 6.
9 p.m. to 6 a.m.?
Yeah.
I think he has to be at work at 6 a.m., right?
So,
Can you
I
come
still
up
do 5 a.m.
5 a.m.? 9 p.m. to 5 a.m.?
This is one of the most serious moments in any courtroom. A guilty plea isn't just doing time, it's a lifetime record. Notice how the judge carefully explains immigration risks, appeal rights, and future consequences. That's the system making sure you understand. Once you say guilty, there's no rewind. Would you take this deal or fight it?
Okay.
so this yesterday, I worked from 6 to 11 at night.
Yeah, I'll give 5 in the morning,
Thank you.
but don't want any more issues.
Natalie Curley, can I do like midnight? Because sometimes it's 30 minutes to drive back home and I get off at
I'm
11.
not giving you till midnight. It's not going to happen. And I want proof of anything that, as far as work is,
Requires like
I'm not going to take
a
your
tub or
word for
something?
it. So I need proof that, that they're actually working at this time, and then we can work on your schedule. But I'm not letting you out in the middle of the night. It's not going to happen.
Sure.
Okay? Thanks.
Judge,
9 to 5, Judge.
9 p.m. to 5 a.m.
9 to 5, right. Yeah.
So we're gonna amend this.
So, Mr. Ibarra, you were charged with driving while intoxicated, second offense.
Sure.
You have worked out an agreement. They're offering you 30 days in jail, credit for the 2 days that you've done. You need to understand something very important, that you are making a lifetime decision today and a very serious one, because anytime you get pulled over from now on, an officer is going to look you up and they're going to see DWI, yada. What do you think they're going to do if they come up to you and they smell alcohol?
Straight to jail. Bring me to jail again.
Right. This time, though, you're looking at 2 to 10 in the penitentiary.
Sure.
Because then a third DWI, it's a third-degree felony. You're looking at a whole boatload of time in custody, up to 10 years in prison. And all you need to do is just have the faintest smell. Do you understand?
Yes, sir.
If I were you, even if you had a sip of alcohol, I wouldn't get into a car because it's a huge risk. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty to this, it will go on your record. It'll stay there for the rest of your life.
Understood.
This is what you want to do.
Yes, sir.
How do you plead to the offense, sir?
Guilty.
I will find you guilty, sentence you to 30 days in jail. I will give you credit for the 2 days that you've done. I am going to suspend your license for 1 year. What do you do for a living, sir?
I work at a refinery. HVAC anything?
Okay. The reason I'm asking you is because there is a surcharge that you're going to be required to pay. We will give you time to pay it, but this is a second offense, so you're going to be required to pay it. It's a $6,000 surcharge that tacks onto you. And if you don't pay it, every $100 you owe, you will sit 1 day in jail. Do you understand?
Yes, sir.
I'll waive the court costs.
Yes,
He's
Your
going to
Honor.
be required to pay that fee.
Yes, Your Honor. And Your Honor, I did have one request that I wanted to put forth before the court. Due to his job, he is a foreman at his job. I wanted to see if possible if the court would consider allowing him to do his jail time on weekends.
No, like
He said he can literally do every weekend until it's satisfied.
we're not allowed to do that.
I explained to him the court's general rule.
Sorry. You're going to have to do it flat. It'll be easier now. If you want to go in later today, by 6 p.m. we can do that. If you want to go in now, you can go do that now, but it's got to be a continuous
Yes, sir.
stretch. What do you want to do? You want to go in now or do you want to go in later
Put it
today?
down.
Right now?
6 Yes, p.m.
Okay. All right. So Deputy Miranda, do you mind remanding him into custody so he can serve his time?
Be back 10 minutes. All right. Thank you, Your Honor. I'll be excused. Have a good weekend. I told him the court's policy, Your Honor, but he
Yeah.
still wanted me to ask.
Problem is that it costs way too much in man time.
Yes,
We don't even do sweep anymore, which is like a work release program. They don't do any of that anymore. Since COVID, it's
Okay.
all,
All right. Thank you, Your Honor. Have a great weekend.
let me see. Okay, guys. Yeah, take care. Yeah, come on up. Hi, James. Come on up.
Sorry about that. I was in court 7 all
Don't worry
morning.
about it. I'm happy to have you,
Mr. Vera is in bond forfeiture for a long time, or? Let me see, Judge.
So you're still on it.
Yes, Judge.
I'd like you, please, because
Sure.
what I'm gonna do now is, I'm putting an ankle monitor on him.
Okay.
Come up, come up.
You mean a GPS monitor or a SCRAM device?
Oh,
Oh, okay. One for each ankle. Okay.
get a curfew of 7 to 7. And then is discovery complete? Please tell me it is.
Yes, it's complete, Your Honor.
You have 2 weeks to figure out what you want to do on this case. You must be back here in 2 weeks and I will either set your case for trial or you will accept a plea bargain agreement. But you have multiple bond forfeitures. You have had bond violation after bond violation after bond violation. Today, you get 2 monitors. One is a scram, so I know that you're not consuming alcohol. The other one is GPS monitor, so I can keep tabs on you. And let me express my, in the event that you ever take off on me, I will do la cucaracha on your bond. Do you understand? You have an offer on this case, please.
Yes, we have both a 30-day and an 18-month probation.
Not to consume alcohol, illegal drugs. You'll be randomly tested. Does he have a Texas driver license, please?
I'm gonna run it right now to see if it's eligible.
There is already from 2023 an order for you not to drive. You are not to drive. I don't care what's going on in your life. If I find that you're driving a car, I will have a contempt hearing. You understand?
His license is suspended.
Okay. You don't have a Texas driver license. You are not allowed to drive. One ankle, you understand you'll get a scram monitor, your other ankle a GPS monitor, and I'm giving you a curfew of 7 to 7. Back here in 2 weeks, you must accept the plea bargain agreement. It is your responsibility to get with Mr. Sims. If you do not get with him, then if you have immigration issues, it's your responsibility between now and then to also see an immigration lawyer as well. Do you understand?
Yes, sir.
Okay.
Thank you,
All right,
Judge.
I'll see you in 2 weeks. You will get with Fleischer for your bond conditions.
That's good. Just, do you want to have a seat in the jury
I can
box?
see him
Judge, or-
right now.
Oh, okay.
Mr. Carollos,
Yes, sir.
sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay,
Just
please.
remind me of the last name, please.
Carollos with a K.
It's K-I-O. Thank you. On or about February 15th, officers paced a vehicle going 80 miles per hour in a 65 mile per hour zone. A traffic stop was initiated. The defendant was the driver of the vehicle. The officers observed slurred speech, an odor of an alcoholic beverage, and the defendant appeared disoriented. The defendant stated that he had drank an IPA juice a few hours before at a friend's house. Standard field sobriety tests were conducted, 6 out of 6 HGN, 2 out of 8 walk and turn, and 0 out of 4 on the one leg stand. The DIC was read and consented to. The defendant blew a .139 and a .131.
Okay, any prior DWIs?
No, Judge.
Okay, Mr. Carollos, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If you test positive for drugs or alcohol, if you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, Your Honor.
You have a lawyer. Because you have one, I will waive your appearance. So you don't have to waste your time coming to court, but stay in touch with him and he'll tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, likewise, I'll issue a warrant for your arrest. Do you understand?
Yes, Your Honor.
I'll have you sign a receipt of Victoria. We'll have you get with Fleischer for bond conditions, and then you guys are free to go.
Judge, one thing I wanted to address, I've already spoken with pretrial services. My client has a work trip scheduled for this Sunday through this Thursday
Okay?
out of state. I would ask, apparently it's not going to be a frequent thing that he's traveling out of state. Would you consider waiving the drug testing until Friday of next week when he?
Well, I mean, from the time of the trip to then, okay, but you're not allowed to use. I'm going to test you as soon as you get back. If you test positive, it's really not going to go well for you.
Yes, Your Honor.
Okay? Okay,
Thank you.
absolutely. Happy Friday.
Happy Friday.
Buenos días, señor.
Buenos días.
Parece aquí, por favor, conteste a voz alta.
Okay.
You are Mr. Pavez Vargas.
Vargas.
Sí.
Yes.
Sir, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine.
De $2,000.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 15th,
El 15 de febrero.
officers
Los
observed
oficiales observaron
Nissan SUV failed to maintain a
que no
single lane
mantenía una vía
5 times
5 veces
and observed it
y
to slow down
observaron que
and
bajó la
rapidly
velocidad
accelerate
y rápidamente aceleraba
several times
varias veces
before initiating a
antes de
traffic stop.
iniciar el alto.
The officer observed the
El
defendant to be
oficial observaron que
and
el
delayed in
acusado
responding
se
to
tardaba
his
en responder
questions
a las preguntas
and struggled to locate his
y
driver's
luchaba
license.
para localizar su licencia de manejar.
The defendant
El
advised he was coming from a wedding
dijo que venía de una boda
and he had one
y que
beer.
había tomado una cerveza.
Standard field sobriety
Hicieron
tests
las
were performed,
pruebas de campo,
4 out of 6,
4 de un 6,
HDN,
HDN,
4 out of 8,
4 de
walk
un
and
8,
turn,
caminar y voltear,
3 out of
y
4,
3
one
de
leg stand.
4 para una pierna.
The defendant consented to breath
El acusado dio permiso para dar su aliento
and he blew a
y sopló
.08.
.08.
You said that he
Eh,
5 times
5 veces
failed to maintain a single lane of traffic.
una vía de carril.
And you said that he slowed down
Su
and then
velocidad.
he sped up.
Yes, Judge.
What else?
¿Qué más?
Because as far as the 5, that's just completely conclusory. So I take nothing with it, right? I mean, everybody slows down, goes back fast. So
Bajan su velocidad.
what else do you have as far as any kind of traffic infraction other than that?
Pico,
That's
aparte
what
de
I'm
eso,
reading in
eso es lo que leo.
this judge. Let me see if there's
En
any
esto,
more
señor.
information in the office.
Su señoría deje ver si hay que no vamos en la defensa, en el reporte.
It does say that
Dice
after the
que
emergency equipment was turned on,
se
the
prendió
suspect failed
el
to
equipo
pull
de
over for
emergencia.
approximately 2 minutes.
que él no se paró por aproximadamente 2 minutos.
I don't know if he articulated more maybe in an OR, but there's just not much there. I mean, Blaze, I can give you a little bit of time if you want to try to pull the OR, maybe like 10, 15 minutes.
Y más para que miren a ver lo que hay. Otros 10 o 15 minutos. Y que no se mantuvo en una vía, en un carro.
Okay. All right, Mr. Pavez Vargas, I'm going to find that there's no probable cause to go forward in your case. Sir, we have enough death and destruction on our streets as it is. Be mindful of this. If you want to have 15 beers, 32 shots of tequila, take an Uber. Save yourself the trouble. Do you understand?
Yes, sí.
Okay, all right, thank you. Please.
Judge, next is page 13, Rodriguez, come on up. Tell us the contact with your press.
With either of the complaining witnesses, right? No going to like bars, clubs.
And just like that, bond revoked. This is one of the fastest ways to end your freedom. Once you're already out on bond, any new charge is a legal landmine. Judges take this personally because it signals disrespect to the court. Be honest, did you see this coming, or did he just throw his last chance away?
Are you Luis Gilberto Rodriguez?
Sir.
Mr. Rodriguez, you were charged with reckless driving. You were facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
14 officers were assigned to traffic crimes in Harris County, Texas, on an operation targeting illegal frequency and parking lot takeovers in an undercover capacity. An officer at 11737 East Tex Freeway in Harris County, Texas, observed the driver of a 2007 flatbed Ram with one multiple donuts in the parking lot. The vehicle was maneuvered in tight circular motions, causing the rear tires to lose traction and produce visible smoke and all extinction. That Ram headed towards the exit of the parking lot when the vehicle executed a burnout, causing its tires to emit smoke and a loud screeching noise. As the driver of the Dodge Ram initiated a turn to proceed east on East Mount Houston Road, while the vehicle fishtailed. During the maneuver, the Dodge Ram flew close to striking several vehicles and almost suffered multiple accidents. The officers conducted a traffic stop on the vehicle.
Got it. Can you look to see any priors of this same or similar nature? Please.
Yes, Judge, I'm not showing any criminal history.
No? Okay. Mr. Rodriguez, or one more thing, if you can look for a license, please, valid license. Mr. Rodriguez, I'm going to find that there's probable cause to go forward with the case. Let me just give you a little warning that the Texas legislature has made it very easy for DAs across the state of Texas to seize and take cars for people who participate in this type of activity. In fact, I think that there was a news conference maybe 2 days ago where they're cracking down on this type of behavior. And I've seen it where here we have people who've had their cars seized and taken when they're multiple times in this. Do you understand? I'm ordering you as a condition of your bond not to participate in any street takeovers, donuts, reckless driving, anything of this nature. If I find that you do, I will revoke your bond and put you in jail.
Yes, sir.
And then I will take your driving privileges away.
Sir.
Do you understand?
Sir.
So do you mind filing that no reckless driving, donuts, et cetera? All right, Mr. Rodriguez, how old are you, sir?
18, sir.
Do you have the ability to hire a lawyer? Would you like to apply for a court-appointed lawyer? Okay. Deputy Miranda, Deputy Miranda's going to give you an application. I'll have you sign a receipt of victoria. We'll have you take a seat in the jury box. Do not leave until you sign our bond conditions. Do you understand? Okay. This is the one where we were, you remember? It was like maybe 2 days ago, the two Bs?
Yes. Yeah. Yes, I do.
Good morning, Ms. Harrison.
Hey, good morning.
Ma'am, you're charged with tampering with the government record. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On February 15th, officers observed a vehicle temporarily tagged. The officers ran a temporary tag and returned to court. Defendant Martin was the driver and Defendant Harrison was the passenger. Defendant Harrison stated that she was the owner of the vehicle and that she had purchased the tag from an unknown individual off Facebook.
Okay. Ms. Harrison, I'm going to find that there's probable cause to go forward with your case. Can you run her license, see if she has a valid Texas driver license, please?
Yes, Judge.
Okay. Ms. Harrison, did you want to apply for an appointed lawyer? Do you have the ability to hire a lawyer?
Apply for one.
Okay. So Deputy Miranda is going to give you an application. Do not drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand? These are your bond conditions. If I find that you're driving without either, I will revoke your bond, put you in jail. Understand, man?
Yes, sir.
Okay, please.
All right, Judge, next is page 7, Huddleston.
Good morning, Mr. Huddleston. Sir, you're charged with tampering with a government record. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On February 16th, officers observed a vehicle with a temporary tag which came back with no return. A traffic stop was conducted. The defendant was the driver and sole occupant. The defendant stated he knew about the tag and had been pulled over the week prior. The defendant stated his mom went to the dealership and bought a new buyer's tag for the car. The defendant did not know how much the new tag was bought for.
So why does Mr. Huddleston get charged then? Oh, it's pled differently. It's pled differently. That's why. See. It's pled here as use as opposed to purchasing, you know? And I think that that's why. So let me see.
And I did notice it showed up as tampering with the record of insurance document, but it looks like on the complaint, it is tampering with the doctor's record. Here, right up to the complaint.
Hereinafter style the defendant heretofore February 16th did then and there unlawfully, intentionally, and knowingly use a governmental record, namely Texas temporary tag attached hereto as Exhibit A with knowledge of its falsity. So one of the parts is it says with knowledge of its falsity.
Yes, Judge.
Does he know of its falsity?
Well, upon the officer approaching the vehicle,
Okay.
he knew immediately what the traffic stop was for. That he'd been pulled over the week prior because of it.
He had been
Yes.
and advised that it was no good. Just read it one more time.
Officers observed the vehicle with temporary tag which came back with no return. A traffic stop was conducted. The defendant was the driver and sole occupant. The defendant stated he knew about the tag and had
Okay.
been pulled over for the week.
Right. Okay. All right. Mr. Huddleston, I'm going to find that there's probable cause to go forward with your case. Can you run his license, see if he has a valid Texas license, please? I am ordering you as a condition of your bond, sir, not to drive any vehicle unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Yes, sir.
These are your bond conditions, meaning that if you don't follow these bond conditions, a warrant for your arrest will be issued. You will go to jail. No more PR bonds. What's more is you are on felony probation. You've now picked up a new case. Best be on the lookout. It's very possible that they now issue a warrant on you.
His license is valid, Judge.
Okay, so you mind filing that then? No driving with that vote, please. Tell me, Mr. Huddleston, do you have the ability to hire a lawyer?
No.
I'll have you fill out an application. I'll take a look to see whether you qualify. All right? Do not leave until you sign our bond conditions. You understand? Okay, come on. Mr. Wilson, you were charged with
This right here is a textbook courtroom moment. Notice how the judge isn't just talking about weed, he's talking about patterns. In court, it's rarely the first mistake that sinks you, it's the repeat behavior. Question for you, should a judge be more strict when warnings are ignored? Or is second chances what justice is really about?
theft. You were facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On August 18th, 2023, complaining witness saw the defendant enter the store, which was a Dick's Sporting Goods, and try on a pair of sunglasses and then request to try on a pair of shoes. The defendant tried on the shoes and placed them back in the box and continued to browse. He then selected a pair of socks and then put the socks and the shoes on and exited the aisle and made no attempt to take the merchandise to the sale. Total value of the goods was $185. Officers reviewed the citizen's video and confirmed that there was no attempt made to pick the goods. The complaining witness was able to recognize the defendant from one of his prior booking photos using a photo.
What does that mean, prior booking photos from?
Are you asking for what? It's charged in the crime?
I'm guessing he has a prior theft at the same place.
He does have a prior theft charge. Let me look up the store.
Does he have any open cases right now?
No, judge, just this theft. The previous theft was from a different store.
Mr. Wilson, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now not to go to any Dick's Sporting Goods at all, anywhere. Do you understand? I'm going to protect everyone in my city and everything. If I find that you become a danger, I only have one place for you. Do you understand? That's not an answer.
So
Better. You have this air of arrogance to you, Mr. Wilson, but you're now here. Really? Do you have the ability to hire a lawyer? Okay, we're going to reset your case to give you time to hire a lawyer. I'm going to have you sign a reset with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it and then you'll be free to go, sir. Mr. Shaw, you're charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 12th, officers observed the defendant's motor vehicle bearing a paper Texas tag. And an NCIC, TCIC search of the tag came back with no result, so a traffic stop was initiated. Officers made contact with the defendant. Defendant said that he purchased the motor vehicle approximately 2 months ago for $2,000 from a mutual acquaintance, but did not have title to the vehicle and did not have insurance or proof of financial responsibility, and that he purchased the tag from a separate mutual acquaintance for $80. The defendant stated that the paper tag was not affixed to the rear of the motor vehicle he purchased, and that he purchased the tag separately until he could have the motor vehicle registered.
Mr. Shaw, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Yes.
You will be signing an affidavit with me today, which is a promise that you're going to make to me that you're not going to drive without either. If you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes.
Bond forfeiture citation on both sides.
Okay. Mr. Shaw, do you have the ability to hire a lawyer? I will take a look at an application. I need you to fill it out for me. I need to know everything about you, what kind of car you drive, how much money you have at the bank, how much money you make. I'll take a look to see whether you qualify.
Yes, sir.
For now, I'm going to have you also sign this affidavit that you're not to drive without insurance as well. You're 18 years old. Have you been to prison before?
No.
Mr. Romero, do you want to take a guess what in God's name they would do to you in prison? You have had already in September, you get on probation. 3 months later, they file a motion to revoke your probation. They keep you on your probation. They extend, or they did whatever they were going to do. And now 2 months to 3 months later, you're back yet on another revocation. Do you have any clue what they would do to you in prison? You and your 18-year-old self. Do you know what they do to 18-year-olds in our Texas prisons? Take a guess what they do to 18-year-old kids in prison. Take a guess. I read stuff that had me damn near in tears because it was so bad what they do to certain people when they go to Texas prison in Huntsville. They literally treat you like a freaking rag doll, pass around like it's a freaking cigarette. You are chattel, meaning a piece of property. That's only the half of what they do to little young children in Texas prisons. You have now are on your second motion to revoke. It's only a matter of time before they say, you know what, this little dude don't get it. Let's send his ass to prison for 3 years. When that happens, you'll be crying for mommy and daddy. And if you don't believe me, start asking the people in jail. They'll tell you. I'm happy to roll it whatever you want, Jillian.
Let's do that. Thank
If
you,
you want to
Judge.
do a week, 2 weeks, whatever you want.
That's
But
fine.
get a clue before it becomes too late and you become a piece of chattel. Okay.
All right, sir. Oh, it's okay.
Mr. Thurman, you're back. Okay. So I told you before, two of my main concerns are, or my two main concerns are, number one, are you going to go back to the jurisdiction that where you're wanted from? And number two, most importantly, are you a danger to my public? I take public, safety. It's as important as my hair. You know what I mean? It's that important, right? Because I don't want anything to happen out there with my name attached to a bond. I try everything in my power to ensure that everybody's protected. And I see that you're wanted for a really serious case. It's an armed robbery, right? I mean, that's what you're wanted for. There's no denying it. That's what it says on the paperwork.
He's on lifetime probation in Michigan.
Lifetime, there's such a thing as lifetime probation?
There is.
Yes.
Whoa.
So that Kate, well, I'll let you do the talking.
No, he did his time and he got out and lifetime probation out of Michigan. So that's what's happened. I believe it got.
So how on what would, aside from like a murder case,
So he was
what
charged
would
with
garner?
murder twice, along with 2 armed robberies.
I wasn't charged twice with no murder.
It just shows up.
It just shows up
Oh, I was about to say, I wasn't charged
Murder
twice.
along with armed robbery or aggravated robbery in our jurisdiction. He's placed on probation. Since that time, he's been charged in our jurisdiction with aggravated assault with a deadly weapon and felon possession of a weapon. In those, he had bond conditions when it started off, where he was ordered to have a GPS monitor. He has had multiple curfew violations on top of that noted. And so I do believe he's a safety risk, because even with literally an ankle monitor, he doesn't follow court conditions. And so I believe he is a safety and flight risk. And the fact that there was a weapon involved with multiple witnesses, some of them children, even threatening to murder them, is that I would be opposed to a bond being set. Also, it should be noted that because of the way the probation was transferred, I can't confirm, so I can't approach on it yet. But from what I see on the system is that he moved the probation to Texas, which means there's an ICA, but I don't have the documents, which is why I can't present them. If there's an ICA hold, he is ineligible for a bond, because that's an ICA hold. I don't have it, which is why I can't say, but if I get the documents.
Interstate compact agreement.
I understand. May I speak, Your Honor? Of course. Okay. After we talking about the probation, I'm at the probation, the GPS curfew wise, my judge knows all that was going on. So he knows every information and why I've been late. I have evidence of why I'm late. So he knows everything that's going on with my GPS.
You're not supposed to be late.
He knows why though. So
I understand.
That's why he overlooked. He said, okay, it's fine. So he said it was fine.
Quick question, is is it a motion to adjudicate?
Well, no, it's still an open case. It's not under probation, but you're just asking if they do a bond violation report. They did on November 1st, 2024. They filed a motion to revoke.
Oh, so it's recent.
It's very recent.
So they've not
this month.
heard, okay, and then so there's not been there's not been a hearing on that yet, right?
No. But that's even after they amended the order. Also, he has further bond violation reports on December 18, 2023, another one on November 28, 2023, and that's after they amended it twice. One moment. So he seems to be agreeing with this. So the fact that he has 3 violations on top of having lifetime probation and a possible ICA, obviously, I'm still opposed for him.
Why are you on lifetime probation?
That's the way they set it up as. I took the plea deal.
What are you on probation for?
The armed robbery conspiracy coming armed robbery. I did 5.5 years, came home off lifetime probation. And to continue what I'm saying, I'm a threat to, a flight risk. I can't be a flight risk. Every court that they set, I came every single time. Every court that Michigan have set, I flew out there every single time. I knew I was getting locked up Monday. They told me that Thursday, I still showed up to court and got locked up. So there's no flight risk in this whatsoever if I'm been showing up every single time.
And you may be showing up, but at the end of the day, you continue to do what you want to do without regard to bond conditions.
And what do you mean by that, Your Honor?
Meaning that they put you a GPS monitor, and they give you a curfew.
Yes.
And you don't abide by the curfew.
I was working, Your Honor. That's why the judge has extended, because they had my probation curfew time I forgot what time it had as. But I had started my new job because I came, got locked up, lost my other job. He said, okay, the violation he's talking about, I came into court and talked to the judge, and he extended my curfew. He was like, okay, you've been working. I said, yes, I have documentation of new work. So I'll show all my documentation, and he said, okay. So the stuff he's mentioning violations for, they already been taken care of. So he's not stating that either. He said 2023 is, obviously I'm still free, right or wrong. I'm still free. That means he's seen all the paperwork. Obviously, I came with legit paperwork.
And that's kind of where I was coming from at it. If it's a lifetime probation and it's curfew violations that he's still out, my speculation would be that he was able to make an explanation to the judge, and that's why he's not been revoked. So he's still here. As to the underlying charge, it's still a charge and that's what it is. Like he said, he turned himself in on Thursday knowing that he was going to get arrested and held. And so I'm sure that Michigan it's a probation violation because of the underlying charges. And plus, that's where that MRP is probably coming from. I believe he's proven time and time again that he's gone to Michigan, taking care of what he needs to take care of, and he will still be here he's been on bond on the underlying case for about a year. Your Honor, he's not been locked up this whole time up until this recent arrest. So, and at this point in time, this is really just for since we don't have proof of an ICA, if the judge is willing to set a bond, how much that would be, if there's a willingness to set a bond.
Let me read this to you.
Yes, Judge.
Okay. Texas Code of Criminal Procedure 17.03, NLR, out of state Michigan, armed robbery, armed robbery with a conspiracy, 2021. Probation transferred to Texas 3/20/21. Concurrently charged with murder, which was dismissed. No holds. Defendant is not indigent, and defendant is alleged to have gone to complaining witness's home and pointed at a gun at complaining witness and complaining witness's 3 children, because one of the complaining witness's children was involved in a dispute with defendant's sister at the child's school. Defendant threatened to kill, quote unquote, everyone in the home. Defendant then left complaining witness's home and came back with defendant's father, both ready to fight complaining witness and complaining witness's wife. That's the aggravated assault that we have now. So, knowing that you're on lifetime probation for a very serious case, you know that you're supposed to be out there with a halo over your head. And yet you pick up an aggravated assault with a deadly weapon where allegedly a gun is pointed at kids I mean, the way your mannerisms,
I would say something, Your Honor, that's why.
but don't though. You have this open case.
Understandable.
Everything they can say, they can use it against you. My concern is public safety, man. And you got to understand that I don't know if you're guilty of this offense or not, but the problem is bad stuff keeps happening to you for some reason. It's like somehow, sometimes people are their own worst enemy. They get out and then something happens and then they just end up picking up another charge. It's like a cold. You pick up another charge, you pick up another charge here, you pick up another charge there, you don't follow bond conditions here. You know, Mr. Thurman, you scare me, man.
Can I scare you, Your Honor?
Yeah.
And I've been out for a whole year since this case happened, and this is my first time being into this courtroom again, and you're fearful whose safety if I've been doing nothing but right and working.
That's not true.
That has been true. I've been out for a year on bond and have not been into this no courtroom, but in Orange Jumpsuit, I should say. Your
I
courtroom,
mean,
anybody's
you want
courtroom.
me to reward you for
I'm
being
saying,
a
but you say you're in fear. You say you're in fear for safety. That's what I'm saying. Like, who are you in fear of? I have not been into any trouble whatsoever. I've been squeaky clean. Just I bonded out.
And Your Honor, to
You
your,
don't get rewarded for being a good person out there. You know what I mean?
I
You're
understand.
supposed to be like that anyways.
I understand that wholeheartedly, Your Honor. I'm just saying, when you say you fear, and I'm saying, how are you in fear if I've not been doing anything? That's showing you, that should show you some type of sign, like, okay, he's not been doing anything wrong. So where is the fear come to play? That's what I'm asking you.
The fear is really because, you know, when people come here, it's little bunnies jumping in the woods, rainbows, gumdrops. And then when they get out there, they turn into different people. It's like Jekyll and Hyde. And I don't want that. Like, I don't want someone out there to suffer because we let you out. I let you bond out. You've got an armed robbery, you've got an ag assault. You continue to violate conditions on those bond, right? That shows me that you're not willing to abide by bond. I mean, quite frankly, you're lucky to even be out on those charges with the ankle monitor, and you continue to violate.
Your Honor, you keep saying violate, like, if I was in violations they have on file, by the way. Those have been taken care of. Once again, you keep on saying violations, but they took care of. The felony court judge seeing I have proven, what's the word I'm looking for? Just proven, facts that this is why I'm late. I have a new job. I got fired because I got arrested from the other job. So I started a new job. For me having a felony in my position, and just call it what it is, a young black man with a felony, it's hard for me to get a job anywhere. So the jobs I do get, I take up on those. So it's hard. Any shift they open up for me, I'm going to take it and show my work ethic to them. So I let the judge know that. He sees that. He understands, like, okay, that's why you keep on bringing up violations. I have to work. I have to eat. I have to have a house to live in, like anybody else here. So you keep on bringing that up. I'll keep saying, I already talked to the judge about it. He granted it already. He let it go. That's why I'm still free to this day. Well, was free to this day. And you keep bringing that up. You saying threat to your fear, which is understandable. Everybody gonna have fear, but I have not been into any trouble. I've been working. I've been working for a whole year. I've been on my P's and Q's. And like you say, the police report that you're reading, sir, the case is still open, so I can't really speak on it. I'm pretty say much, but it's a lot more to what you're just reading on that police report. It's always gonna be video cameras and house ring cameras, body footage. It's gonna be a lot more other things that you're not gonna be able to read off a police report, which is understandable.
Just too much blood, Mr. Thurman. I'm sorry. I can't set you on. It's just too much. I'm sorry. Hey, this isn't.
Do not walk away.
This isn't.
I said, okay, it's fine.
Really. I understand that you're hurt, Mr. Thurman, but look.
I've been doing my best, and y'all sit here telling me I'm the bad guy, and I've been doing nothing but my best of my abilities, working, staying out of trouble. And you're a threat, and I'm a threat to society. Really? For a whole year, I've been out, and they just not issue a warrant for me just now, recently. And I come to turn myself in, and I'm a threat to society. And people, if you fear me for what? From turning myself in and show you that I'm not running for nothing. I'm not running for anything. I'm innocent, and I'm coming to show you I'm innocent by turning myself in. But y'all a threat. You can let go of me, sir.
Stop.
You can let go of me.
You don't not tell me how to do my job.
You can let go of me. Grab my arm too tight.
Guys, relax.
Arm too tight. All I said, grab me. Look how you grabbing me up.
Back up.
Look how they grabbed me. I said, you let me go a little bit.
You gotta calm down.
I'm calm. I just asked
You're
him a
not
question.
calm.
I asked him, I should let me go a little bit, sir. That's all I said.
Open the door.
That's all I said. What do you make somebody cuss you out or anything? You said I'm all type. You listen up. You know what I'm saying?
So he already waived, so if he
He did.
just holds it, then it.
Just, yeah, I
Yeah,
can't.
I'll go talk to him, but once again, Judge, understandably, I think I know that he's frustrated, I believe.
I understand. I get it. And I would be too, but I can't. That's just too much blood. It's too much. You know,
It looked like there was.
even, you know, and I'm going to tell you, even if he didn't have those bond violations, I'd still be very hard pressed to even, you know.
No, and I was curious because when you brought it up, it was a little bit older, and so I was wondering why.
Do you know, are they going to come get him?
Oh, no, they're gonna get him. I was trying to figure out why now, and they were just having back and forth.
But here's the problem. So he hasn't made bond on those cases. So we're sitting anyways.
Yeah.
He has not?
No.
He said he did.
No, he's not made bond on those cases. He's
He's been
basically,
in jail for a year?
No.
he may have, but they revoked the bond.
Ah,
Yes.
So he's sitting there and I
There you go.
didn't have the heart to tell him right now that the 14 days is not going to apply.
Yeah.
Because
I gotta do that.
Well,
I will, really.
I would
I
imagine.
will, I'll let him know.
I would imagine it's gonna get resolved because it's one of those, it's a bizarre. So we revoked, Harris County revoked because Michigan revoked because it was charged with the ag assault. So it's a chain of events because the only thing the court sees is that they revoked
So-
on the probation, which was caused by.
Please let him
events.
know that the 14 days hasn't kicked in and it will not.
It will not kick in.
Resolves.
Right.
And either he resolves the cases.
So which one does he need to resolve first in order for,
Well, for the felon possession of the weapon, there's, hold on, I don't want to see.
Is there an offer?
No, it's going to trial. That's why it's been reset out. It's been set for jury trial at least.
four
Really?
times?
4 times, 1,
Yeah.
2, 3, 4, 5, yeah.
5 times, Judge.
Next time is January 6th, 2025. But he's held on 55,000 bond for the ag assault and 55,000 for the felon possession. So he has to come up with 110,000 for.
Wait a second. So
So it doesn't matter what you did today.
can't,
Right.
even if I gave him a bond today, he would still have to make those bonds.
110,000.
So my question now is, when did that warrant for the felonies pick? Because he's saying he's been out for a year ever since this
I'll
ag
tell you.
assault got picked up.
I show a remand defendant custody on November 18th, but I don't know what the previous.
So the only reason why his felony bonds got revoked was because Michigan
Well,
revokes.
I should
Oh,
say
no,
only.
it doesn't, but we don't know that for sure.
Yeah.
Because it doesn't, there's no notes that reflect why they revoked the bond. It just says court directive remand defendant to custody. Let me see if they give an explanation. Hold on.
Okay,
It's remand custody, violation report, but that's not a revocation. Yeah, because,
it's a violation report from Michigan?
no, for me, so remember when I said the newest violation was on November 1st for all the curfew violations?
Mm-hmm. Is that from here?
Technically, that could be the reason why they revoked instead of Michigan. I don't know, because I don't have the document. And
Yes.
So.
But he
technically,
hasn't gone out to Michigan to, I guess, take care of.
For that
the
one,
current
that
bound
one
violation.
since 2023, so it would have predated.
I
It
get
just
you.
takes some time for them to do it, which is why I hate it, because they should have waited to file it. But whomever originally had him, well, actually, if he said he was in the courtroom, it could have happened. Yeah, sheriff's office, so they should have known to wait and file.
I got you. Okay.
Okay, well, I guess reset to track locals. Oh, man,
Don't set it to January.
I'm not. When in
So-
December would you like to touch base?
Now, my question now is, does it matter for us to touch base if his locals are gonna be reset far out? What's the
Yeah,
point of?
Yeah, we have to,
If they,
you
if
gotta
they
keep
do like
it.
a plea deal, pre-trial,
Ah,
yeah,
makes sense.
or mid-trial dismissal, because it's Troy Locklear on the one.
So let's do this. Do you see a date for like a pretrial motion or a pretrial setting for them?
Trying to file a motion.
Highly doubt it,
File a
Judge.
motion, I mean, there's nothing between here and there. Judge Jones, I would be surprised if they set another
Okay. Can
So
we
if
do
you wanna talk to Troy-
18th, 17th of December?
17th of December.
Finner? Is it Troy Finner?
No.
Troy Locklear. So hold on,
Oh, yeah.
December 17th.
I don't know. I'll find out.
Yeah,
All right.
okay.
17th or 18th, whichever one of those days works for you, I'm good by it.
I live in this building, you tell me.
And if you have any problems with him, just, we can bring him back out as far as just tracking locals, meaning that just let them know they revoked the bond.
Oh,
And
that's-
essentially, the time here, it's kind of told until he either gets a bond reinstated, post bond, or somehow deals with the case.
Because the bond is set, so if he can come up with the money, he can. But I'll put 17th, and then if you want it sooner or a couple days
Got you.
out, let me know. And I'll
Sounds
see you
good.
tomorrow for.
Yes, sir.
Okay.
I think
Thank you, Judge.
we are done.
Maybe excuse Judge.
Oh, my God.
And Your Honor, I filed dismissal on moves. I emailed.
Come up, Mr. Burrows.
Also, we did the TRS. And, I was in the process of appealing this on Friday. I was going back and forth with Nathan.
Appealing.
Appealed for a P-tip. And,
Oh, so they denied him?
No, we're almost there. P-tip, the decision, and then this came, so I just, I'm really excited to talk to you. I told him about this on Friday, and he drove straight to the free trial services. I think that was mouthful test because- But, that's what's going on with him. Just tell you.
But so, but I don't understand what you're saying about appealing. What are you?
No, I'm doing a P-tip appeal because he's not necessarily allowed to P-tip what the situation is, so I did.
You're doing, you mean you're doing a mitigation packet?
I already did it. Everything's turned in. I did everything, mitigation, mitigation packet.
They said yes.
I don't know yet.
Oh, you don't
So
know?
we're going back and forth, and then I stopped that because I literally, I got that report right then and there. I was going back and forth with Nathan on Friday.
Do you guys have any guidance on Burrows? It looks like he's filed for the diversion program for the DWI.
Amanda? Is that
I'm
your
just
name?
whether he's been accepted into the program.
No, are you Amanda? I'm sorry.
I'm not.
Oh, I'm sorry.
She works for the recovery unit.
Okay.
So I believe that Nathan he was waiting because there was a previous DWI that was filed out of county, and he was waiting to receive the OR from that previous DWI. Because we don't know, it might have been dismissed.
No, it was dismissed. I gave him the dismissal paperwork, and it was because there was nothing on
But
it.
I still have to know too, so I can take the appropriate action as far as bond condition. You know?
Happy to email
Go ahead.
Nathan right now. I think we just received the OR this morning
Where from and when?
from Galveston County. Let me look for the judge.
This case has been open since June. And I'm just now finding out that he had.
I didn't know it either because he thought it was expunged because it says interest adjustments, no evidence for DWI, basically. It was like, he had no, it was nothing, just got thrown out. So that being said, he said he didn't do anything. That's whatever, that's that, but
Yeah, I think it had been, I think that we are all in agreement that it was dismissed. I think Nathan just wanted the copy of the offense
What
report.
year was it?
1 second, Judge. Yes, Judge, the DWI is from 2019.
Yeah, I probably would have put an interlock on him.
but the reasoning on the dismissal, he put it on there.
And now he's still consuming alcohol, Mike.
That's what I'm saying. He's here to tell you, I don't believe that's the case. He swears up and down he didn't. He puts.
Have a scram.
I understand that. And he puts some like crazy amount of makeup on him, and the alcohol, I give you the pictures of it also. It's called alcohol what's it called? Hang on, he can explain it to you, but I have it here.
I have pictures of.
The nature of alcohol can be mistaken for alcohol consumption. I know.
I have these pictures. It has no date. It has no.
To give you context to it, I have the dates here. Those are just pictures of the close-up makeup, but he was DJing on those particular dates. And I have it right here because I was trying to get it in the club.
And I guess drinking while DJing, right?
No, he said he wasn't. I mean, you talked to him. I wasn't there. It was DJ Sidney Ray, October 31st at this place, and that was the day in question. And then this is October, this one, I'm sorry.
Okay, so
October 27th.
I have here that you're consuming alcohol. I have here that the consumption is October 26th.
Yeah, that's the, it believes in
October 30th,
November 9th.
November 9th. Oh, and October 9th. So
That was, yeah.
I have 4 different events that you're consuming alcohol.
For October 9th, Your Honor, that was whenever you told me to put the scram on, and I put the scram on right after that. And then those other 3 dates.
So you're allegedly consuming alcohol the day I tell you to put it on.
No, he did it that's the day, and then he put it on. No, that's the violation. We addressed that.
I have a positive for alcohol on the 9th of October.
Not from the scram, I think.
Yes.
October 26th.
I sent him on 10/9. So Felicia,
Yes, Judge.
so we sent him for a POC test on 10/9 on that time. Did he test positive for alcohol?
Yes, Judge.
Why on earth are we just now getting the violation?
The violation
No.
was already addressed.
That was addressed.
Yes, that violation was already addressed in a previous BVR. They started to put it in that section, that's why I didn't highlight it. But I
Did I
don't,
address that BVR?
yes, and that's when we amended the conditions to put a scram.
Okay, so now we have alcohol consumption as a second violation on top of all this.
For the scram itself.
I've been very grateful for the second chance you gave me. That was from the makeup that I applied to myself, and I was just ignorant to the fact that that would actually set off my scram device, but I have not consumed another alcohol beverage at all. Those are also the days that I was working, I was entertaining, I did not consume another alcoholic beverage at all, so I've been very grateful. I'm not stupid, I wouldn't consume another alcoholic beverage after you put the scram device. in the
Mr.
cell.
Burrows, I told you at every single stage of this game, do not put anything into your body that could be positive for alcohol. It is your responsibility to know what you can and cannot use. You're old enough to know that actions have consequences.
Yes,
And
sir.
here we are. I've already let you go one time with a positive for alcohol. When I told you not to consume, you literally tested positive on the day that we sent you for the test. And now we have another 3 positives for alcohol.
I don't think that's all, that's the other parts, yeah, but the first part, that's not, he didn't test positive.
He tested positive 10/9.
No, that was,
It was a positive urinalysis test, and because of that, we amended the.
And because of that, I amended the conditions. I did not put him in jail. I put the scram on him.
yeah, but we addressed that he didn't go in and like.
I got it.
It's not 2 tests, is what I'm trying to say.
Okay,
You're right.
but he's continuing to consume.
So, yeah.
Stephen,
The scram reports are also in your email, I'm not sure if you picked them, but we got the notice of the records as well for all of those dates.
have you seen that?
I have whatever I was sent yesterday.
That's it.
I'm sorry, Mr. Bros. What am I supposed to do? Just let you go again?
No, sir, I'm not asking to, and I did not consume any alcohol. It was just yes, sir. The products that I put on, and I just was not aware that that was set off that. And it was makeup, sir. That's all it was. I didn't consume an alcohol beverage at all.
That party is 10:31 and I have here 10:26, 10:30, and you're telling me that you put this makeup on November 9th? Is that what you're trying to tell me?
Yes, sir. It's for my TikTok, and I have the videos of it also, sir. I do cosplay, and I just put on those products, and that was the sweat from it. I had no idea that that would actually get inside my blood system and and set that off.
You have levels?
Yes, they're in the scram report.
What is it?
I have.
It's like a peak of 0.08, and then.
He's a 0.08.
Yes.
You're telling me that makeup made you a 0.08?
Yes, sir. And those are the days I was at work.
I don't believe it for a second.
I even have.
I don't believe it for a second. I'm sorry. A
Understand.
0.08 because of makeup?
Yes, sir. I understand. I promise you I have not consumed alcohol at all.
I'm sorry, dude.
I
That's
understand.
it.
Yes, sir. I understand.
With you?
I understand, yes, sir.
And possibly believe that makeup is going to make you as intoxicated as having 6 to 8 drinks.